Hello, and welcome to Healthcare Matters, where the medical and legal communities come together to discuss healthcare matters. I'm your host, Mike Matray, and today's guest is Troy Bundy. Mr. Bundy is a hiring partner at Hart Wagner in Portland, Oregon, where he has been defending healthcare professionals since he joined the firm in 1996. Welcome to the show, Troy.
Thanks, good to be here.
One of the hottest trends employed by the plaintiffs bar in medical liability lawsuits recently has been the Reptilian Theory. Can you explain the concept of the Reptilian Theory, how it influences juries, and how the defense counsel can diffuse this strategy?
Yeah, the Reptilian Theory pokes its head in from time to time into my trials and into the discovery process. But basically, as I understand it, and I've read through there's a couple books out on it, but one in particular called Reptile, which I've read over just so I can stay on top of their game. But the idea is that, in a nutshell, you want, if you're the plaintiff, to talk about safety and protecting the public and making sure that procedures are safe and standards of care exist as a safety measure. And so during the course of discovery, you might hear questions in a deposition like, well, is this safe practice? Or you do that because it's the safe way to do it, right, doctor? And that kind of stuff comes in all of the time. But, safety is not synonymous with the standard of care. And that's the fallacy. So the story that the plaintiff's attorneys that use this strategy are trying to sell is that, hey, this is all just about safety, and this doctor was unsafe, and therefore, they should have to pay a lot of money. And they're appealing to this reptile part of the brain that they call, which is that jurors are ultimately self-interested and want to protect themselves and their families and their loved ones from events like this occurring to them or others in the future. And so that's basically, the theory behind it. And my experience with it is that it doesn't really work, at least in our setting. The objections that I raise during trial are typically, I object that's not the standard of proof. Safety is irrelevant. And most of my witnesses are prepped to deal with the safety type questions, and the prep I typically discuss with the expert, if it's appropriate, is, medicine itself, a surgery, for instance, is not safe. Nothing is safe as the jury wants to hear it is. There are risks and there are degrees of risk to every type of procedure that a patient can undergo. Some things have a higher risk than others. But ultimately it boils down to surgical judgment or physician judgment, depending upon the procedure that we're talking about. And so I think that the best approach, at least the one that's worked the best for me, is to kind of turn the argument on its head and say, have the response be, well, your use of the word safe is confusing to me. And it implies that doing it another way is unsafe. Here's the deal. As a physician, there are degrees of risk, and some risks are worth taking and others are not. Some risks or some procedures are very risky, but there's no other option. Some procedures, there are different ways to do it. They both have different kinds of risk. Each one is extreme. So I think breaking down the question into terms of risk rather than safety, because safety really isn't a fair question to ask about, especially when you're talking about a medical setting. It allows the physician to answer the question fairly, which is really what it's about. But most of the time, I've seen the plaintiff's lawyers dabble in this idea using the reptile strategy, as they call it, but they usually abandon it after a few objections are sustained. And if the objections aren't sustained, then I will attack the theory head on with my cross-examination, or usually my redirect examination of my own witness, because it usually comes out in cross-examination, and I'll just say, there was all this talk about safety this, safety that. When someone asks you, is this procedure safe? If a patient were to ask you that, for instance, what would your response be? And that kind of gives them the ability to start talking about, hey, there are no guarantees in medicine, which is typically a standard jury instruction. We don't, guarantee a cure, and we are invading your body when we're performing surgery, or something significant is happening to your body that we are trying to deal with, whether it be a birth or some other procedure like that. So it's all about explaining to the jury that this isn't all fun and games. There's always risk. There's a risk in getting a tetanus shot. You can get an infection. You can have any number of things occur as a result of that. You can develop an abscess. And so no matter how small a procedure, there's always a risk that you cannot completely eliminate.
So it's basically you're trying to redirect the jury's attention to the fact that the standard of care is the question in front of them.
Right. Yeah. It's not about safety. It's not even about what's more safe than something else. The question, in medical terms, doesn't make sense.
Well, Troy, I'd like to thank you for coming on Healthcare Matters today. It was wonderful to have you as a guest, and I hope you'll come on again soon.
Thanks.
You were involved in a significant case in Oregon, which involved shoulder dystocia. Could you tell us about that case and what made it significant and how it played out?